Good morning. Good morning, everybody. I think we're all having a great time already, aren't we? Yeah, so far it's been a wonderful conference. So welcome. My name is Brian Leopard. I'm a professor of law at the University of Nebraska, and I am also chair of the BILA Committee on the Formation of Rules of Customary International Law. Quite a mouthful, but we really do focus on identifying customary international law and what is its role in contemporary international affairs today. And in fact, that is going to be our theme today. We're going to look at what role can customary international law play in responding to contemporary global crises. And I think this is a very timely topic, obviously, as we've heard already, and we're very familiar with. Right now, the world is really buffeted by multiple crises, and these, of course, touch on many areas of international law. Peace and security, obviously, human rights, the environment, and so many others. And so we are going to have an opportunity to explore with our very distinguished panelists what role customary international law can play. And we're going to look at its strengths and its weaknesses, particularly in the tumultuous conditions that we face in the world today. And it's an interesting time to be looking at this topic, both because of the seemingly not only prevalence of crises, but even acceleration of them, but also because we're seeing increasing references to customary international law. Indeed, the International Court of Justice, just in the last year and a half, has issued some very significant advisory opinions that have referred to customary international law. They've played a major role in these advisory opinions, and we'll hear more about that today from our distinguished panelists. And so we're going to look at, what are some of the strengths of customary international law? Can it play a stabilizing force in a world where treaties are often disobeyed or withdrawn from, but also does it have some inherent weaknesses, especially in comparison to treaties? In particular, typically at least, it requires some period of time for its formation. So what I'd like to do is just take a few minutes for the benefit of everyone to review some of the fundamentals of customary international law, because I realize that many of you may be students, you may be new to this field, and I want to make sure that we all have a clear understanding of those basic principles. And then, of course, I'd like to introduce then our distinguished panelists. And we are going to, by the way, try to make this a dynamic discussion among the panelists. But also, we want it to include a dynamic discussion with all of you. And so we are going to do our very best to allow about the last half hour of our panel time for you to engage with the panelists. So first of all, just by way of background, perhaps many of you already know that customary international law is one of the foundational sources of international law recognized in the statute of the International Court of Justice in Article 38, which is widely recognized as an authoritative statement of sources of international law. Of course, treaties are one source, but then the statute refers to international custom as evidence of a general practice accepted as law. Now, that statement itself, I think, demonstrates some ambiguities. What is an international custom, and what does it take for that custom to become law? And so it has become accepted that actually that formulation in the statute does convey two essential elements for a norm to be considered customary law. So first, there must be a general and consistent practice among states of some kind. It could actually include a practice not only of doing something, but of abstaining from something, such as torture or targeting of civilians in times of armed conflict. But then second, there must be an acceptance of that practice as law. That is to say, states believe it has a legal character. It is not merely a matter of convenience or even of just custom. It is accepted as legally obligatory. And this two-element definition was recently reaffirmed by the International Law Commission in its conclusions on the identification of customary international law. And we are, of course, very gratified to have the distinguished special rapporteur of the International Law Commission, Sir Michael Wood, with us, who I'm sure can elaborate on this. And indeed, I should say that he and Omri Sender have co-authored a wonderful book entitled The Identification of Customary International Law, which has just won an award from the organization, ABILA, as the best practitioner's book. And so there are these two elements then. We often refer to that second subjective element, belief that the norm is legally obligatory, as opinio juris. Now, one of the signal features of customary international law that I think can give it a special role to play in responding to crises is that it is considered to bind every state in the international system, unless, and they have persistently objected to that norm since the very first time that it was proposed. So we call that the persistent objector doctrine. But this does give customary international law a potential really great power, to the extent states actually recognize it and try to abide by it, to affect their conduct and international relations. Whereas, as you know, treaties formally bind only those states that have ratified them. So I would commend to your attention the conclusions on the identification of customary international law that were not only adopted by the International Law Commission, but then ratified, so to speak, approved by the UN General Assembly in its resolution 73-203 from 2018. So at any rate, that's a little bit of background. Hopefully that sets the stage for our panel's discussion. So again, without further ado, I would like to introduce our very distinguished panelists. And I think I'll just go alphabetically, but well, I can go in order here. So first, I'd like to introduce Dr. Nora Abou-Yadvi. So she currently leads the Legal Affairs Office of the European University Institute in Florence. Before joining the EUI, she held lectureships and postdoctoral positions at several universities, and she also worked at the United Nations Rule of Law Unit. Her research and publications focus on customary international law, norm development, and international institutions. And I should mention she has her own co-edited book that came out with Cambridge University Press just a few years ago. Excellent book. Adil Haq is Distinguished Professor of Law and Judge John O. Newman Scholar at Rutgers Law School. He writes on the law and ethics of armed conflict and the philosophy of international law. His first book, Law and Morality at Work, was published by Oxford University Press in 2018. And then I'd like to turn to Una Hathaway, who we are very privileged to have join us from Berlin, where she is teaching this semester. So she is the Gerard C. and Bernice Latrobe Smith Professor of International Law at Yale Law School. She is Professor of Political Science at the Yale University Department of Political Science and faculty at the Jackson School of Global Affairs, and also Director of the Yale Law School Center for Global Legal Challenges. So I could probably go on. Those are at least 4 distinguished titles. So she's also President-elect of the American Society of International Law. So she's joining us from Berlin, as I mentioned, where she's a fellow at the American Academy in Berlin for this fall term. And then finally, as I mentioned, Sir Michael Wood, even more distinguished title than doctor. Yes, of course, we academics like to think doctor is the eminent title, but indeed it is actually Sir. And so Sir Michael Wood, KC, is a barrister at 20 Essex in London, where he practices in the field of public international law, including before international courts and tribunals. He was legal advisor at the UK's Foreign Commonwealth Office between 1999 and 2006. He was a member, as I mentioned, of the UN International Law Commission from 2008 to 2022, and, as I noted, its special rapporteur on the identification of customary international law. So we are so pleased to have this very, very distinguished group of experts to help us understand what role can and indeed should customary international law play in responding to the contemporary global crises that are now buffeting the world. So I'd like to begin actually with a question that really builds on the overall theme of this conference, which is crisis as catalyst in international law. So I'd like to ask the panelists, and not necessarily all of them, but those who'd like to respond, in which ways have crises historically served as a catalyst in the development of customary international law norms? And are recent crises serving as such a catalyst? Are we kind of living in the midst of a process where new customary law norms are being generated? And On the other hand, are there risks in changing customary international law, in creating new norms as a result of contemporary crises? So why don't I turn to you, Sir Michael, first of all, for your reflections on this question. Thank you.
Well, I'd rather not answer that question.
That's a good way to start.
Say, in creating customary international law, we've got to remember that it's states that create customary international law. It's not academics who write theoretical books about the subject. I'm going to be quite frank.
I'm not thinking of anyone in particular there, right?
Master the technology. The crises, what crises? Well, climate change is an obvious one. I think perhaps human rights crises, crimes against humanity is an obvious one. But the one I've selected, and I selected it this morning, so I didn't tell you about it. I think the current crisis in international law itself. How far can customary international law assist with what's going on in the world at present, the crisis in international law? I think that I used to always take the view there is no crisis. There's always a crisis. It's not that serious. People every 5 years write about the crisis in international law. But as of perhaps yesterday, I've more or less concluded that that's not very appropriate these days, and perhaps one should be thinking that international law really is in a state of crisis, and what can we do about it? And there I do see that customary international law has a very big role to play, because as you've just mentioned, treaties are treaties, states can often withdraw from them. Not all states are parties to them, they're very partial in most cases, they're not in connection with the laws of war. But nevertheless, they're of limited use. Whereas with very few exceptions, customary international law binds everyone, and it's very hard for one state to change it. In fact, it can't. I used to, of course, in the Foreign Office, advise Mrs. Thatcher, and I was always very comforted by the thought she cannot change by herself customary international law. You know, I can just tell her it's that, and then she's stuck with it. And unless she can get all her colleagues around the world to decide to change it, they can't. So I think it really has a stabilizing influence, even in these very difficult times. Just to indicate the sort of crisis which dawned upon me really yesterday, I suppose, when I saw what the foreign ministry of a great country said about the principal judicial organ of the United Nations, what I think is called a tweet, I'm not sure. But anyway, from this foreign ministry, it referred to the principal judicial organ of the United Nations as a so-called court. And it said that the opinion that it issued on Wednesday was another corrupt ruling by this so-called court. So I really do begin to wonder if a country that has been one of the greatest supporters of international law over the years and for a century, perhaps for 2 centuries, is saying things like that officially, because I believe tweets are official. Anyway, they've been sending it around. I really find that very shocking. And it went on to say that the ICJ's ongoing abuse of its advisory opinion discretion suggests that it is nothing more than a partisan political tool which can be weaponized against Americans. Well, actually, there's some truth in that, I have to admit, but it's not put in very diplomatic terms. And I think if there is some truth in it, it doesn't apply to the advisory opinion that was given on Wednesday, which I personally, at first reading, see as one of the better and more thoughtful advisory opinions that's been given. And it's of great interest to our subject because it does rely quite heavily on customary international law. And I try to deal with the technology and see if I can find it. But essentially, they said a lot about customary international law. There's about 20 or 30 references to it in the advisory opinion, and 2 of them are particularly significant because they deal with central issues. They say that well, I can't find the quotes, but one of them is where they say that the prohibition of starvation as a weapon of war is a rule of customary international law. And they quote the statement to that effect that you find in Additional Protocol 1. But of course, a lot of countries are not parties to Additional Protocol 1. So it's important that it's also customary international law. And as such, it binds the whole world. And there are a couple of other quotes like that, which I think are very important. And this field of IHL is one where customary international plays a huge role, because a lot of the rules are only in Additional Protocol 1, and some of the key countries are not parties to that. A lot of the armed conflicts are non-international armed conflicts, and customary international law is relevant there. So I do see it as really important as a stabilizing role in these times of crisis. Advantages of customary international law. It's sometimes said that it can only develop slowly. Indeed, you said so almost. But actually, it can develop very rapidly. If particularly under pressure of a crisis, and one could give examples of that, I think it can develop at least as fast as treaties. Treaties these days take years and years to negotiate. Look at BBNJ, it took about 20 years, and it's in force for about 65 states or 80 states now, but that's only half the world. The Paris Agreement, admittedly, was negotiated very quickly and came into force very quickly, but it can also be left rather quickly, as we see, which throws you back onto customary international law. And I won't speak about the climate change opinion, but that does show how important customary international law is in that field of crisis. So I think the main current crisis of international law, which actually is probably more a crisis of international lawyers rather than international. Blame the lawyers, because they come up with these very strange ideas. They, these days, spend most of the time arguing among themselves rather than arguing with governments. So I really think that academic international lawyers should be more careful when they try to destroy or come up with new ideas that undermine the law. So this is rather rambling, and I'll stop there. Okay, I've said enough to invite a few questions.
Thank you. I'll try not to take those remarks too personally.
They were meant personally.
Yeah. So what is your perspective on the role of crises in changing customary international law?
All right, thank you, Al. Thank you, Brian, and thank you, Sir Michael, very much for that. I would start by saying, continuing what Sir Michael said, that it's not the academics who make custom, but it's also not the courts. The courts are there to interpret, maybe identify customary international law. So I haven't looked at the latest advisory opinion very carefully, but I believe the court refers largely to the ICRC study on customary international law, rather than delving into looking at practice and opinio juris. But this is moving a little bit away from what I was intending to say. So my key argument would be that the crises historically have both destabilizing and reinvigorating effect on customary international law. And what I mean by that is that they can expose obsolete norms and create political pressure that might be necessary for change. At the same time, crises can also generate opportunistic interpretations that corrode normativity of customary international law. And I know I'm delving perhaps into theoretical arguments here, but I think it's important to also take note of how theory impacts practice and vice versa. As Brian noted regarding custom, international law often changes and arises not through deliberate lawmaking, but through acts that may contest the existing law. Sometimes this could even be done through breaching the existing norms. And here I'm referring to what is known as the chronological paradox of customary international law, that if we have a norm of custom, how can it change? Well, by contradictory practice and contradictory opinio juris, which may mean that you need to initially be violating the existing norm. And thus, the crisis may lead to behavior that and signal the beginning of a new law rather than collapse of the old one, even if these sort of go hand in hand. Now, some examples I was thinking arise in the post-1945 framework, which itself arose from a crisis. So what we have seen with regards to Articles 2.4 and 51 of the UN Charter, so I'm referring to treaty law that is also largely recognized as customary international law. We have had subsequent crises, for example, in Kosovo, Libya, Ukraine, that have been testing the durability of these norms. And not only these particular norms, but the extent they may affect other related normative frameworks. I often like to refer to the ICTY as a historical example that was created during and in the aftermath of a crisis in the Balkans. And there in the court, they had to find ways to refer to customary international law, given that not all the states that emerged from the former Yugoslavia were parties to treaties. So there is my favorite quote where the court said that the demands of humanity require them to find customary international law. And I think that nicely encapsulates what crisis can do. So in a way, you may have to find the normative elements to say that we have a rule that is either allowing or prohibiting certain behavior, but at the same time, it may open up the system to a lot of critique when you are bringing in demands of humanity or considerations into the law identification, or what may be identification lawmaking under the disguise of interpretation. Now, crises reveal when formal mechanisms for change may be blocked. So during the crisis, you are unlikely to be able to negotiate a treaty that would be directly relevant to address that particular crisis, unless it's done by those who are not really directly parties to that crisis. So states may be acting outside of the existing law, but they might even declare a normative purpose. I know here I'm taking a bit of a leap towards even more theorizing approach, but I think there is still some practical elements there. So I've been looking and thinking about something that we could identify as perhaps principled non-compliance. And going back to, again, what I said about the chronological paradox. So if we would have principled non-compliance against an existing norm, that may indeed be the bedrock of an emerging new norm. But that would mean that it has to be pursued in a clearly articulated legal manner. So I am not going to go into very concrete examples here, but you could think of a situation where a state declares that what they are doing indeed is legal, even if it may seem to breach existing customary international law. And they might even provide reasons for that. It might be that there are other states who would support this practice or this behavior that then could be seen as practice if it's followed by others. And the statements may go along to support such behavior. So there we might be looking at something that becomes overall new practice. And here it can, as I started by saying, that it can be very, very great catalyst for customary international law to emerge from a crisis, but it also can open up this opportunistic way of misusing that tool. And as I said, I don't really want to go into specific examples, but I think it's something we can think of and identify. And I guess to finish off this part, I think we need to go back to what John Merrills wrote in 1976, that law breaking can be a form of law making. If there is this sort of feedback loop of practice and justification with also clear relevance of communicative practices, so practice and opinio juris, but in creating a new norm.
Thank you, Nora. So it does suggest that there is a potential dynamism in customary international law, an ability to change, perhaps through this process, at least in part, of principled noncompliance, which then, of course, brings us back to a question I posed earlier, which is, what are some of the strengths, also weaknesses of customary international law in relation to treaties when it comes to responding to global crises? And so why don't we just focus a bit more on that particular question. So I'd like to turn to Una. Hopefully our technology will work. And
Hi there.
Have a perspective on that.
Hi, everyone. Thanks so much for having me. Can you hear me okay?
Yes.
Okay,
Wonderful.
good.
Thank you.
Well, I think Michael covered a lot of the ground in key ways. The fact that, and Nora as well, in the course of a crisis, treaties, new treaties are highly unlikely to be negotiated. And so in the course of a crisis, you really have a couple of options. You have interpretation of existing treaties, and then you have customary international law to help you fill in the gaps and answer the question as to how international law might respond. And I think we've seen in this recent slew of opinions that have been coming out of the court, increasing and fairly heavy reliance on customary international law principles in response to crisis situations. In addition to the opinion that was just mentioned, the customary international law played an incredibly important role in the ICJ opinion on climate change, which is arguably the kind of critical crisis of our moment that we face. The court focused on the duty to prevent significant harm to the environment and the duty to cooperate for the protection of the environment as customary international law principles that played a critical role in its understanding of the role of states and the responsibility of states in responding to global warming. And so that, I think, illustrates the ways in which customary international law can play a critical role. Another one that we haven't discussed yet that I think is important and maybe worth bringing out at this stage is the role of countermeasures doctrine. So countermeasures doctrine is largely a creature of customary international law. For those who don't know, it refers to the legal mechanism that allows an injured state to take an action that would otherwise be unlawful, but they can take that action in order to compel another state to cease an internationally wrongful act. And the wrongfulness of their act is precluded by the fact that it's done as a countermeasure to try to bring another state into compliance with international law. Countermeasures doctrine is, again, largely a customary international law norm, but it's a really powerful tool for enforcement of international law in the day-to-day cases, but also in the midst of crisis. Not only for states that are directly involved, for other states that might be affected by the internationally wrongful act of another state. So this is another way in which customary international law plays a critical role in moments of crisis, giving states a tool to be able to respond to internationally wrongful behavior by another state and perhaps fill in some of the gaps that otherwise are left by existing treaty law. So and I think we're seeing again how important this is in many of the recent crises that we've been facing, not least in conflict situations where international humanitarian law has been critically defined by customary international law for a lot of the states that are not party to Additional Protocol 1, and where a lot of the critical rules, as Michael rightly said, are laid out. But many of those rules are also customary international law, and therefore that has played a key role in defining the duties and obligations that states have in the context of some of the international conflicts that we're facing today. More to be said, but I'll stop there so that leave room for my other panelists.
Okay. Wonderful. Thank you. Thank you. So Adil, do you have some reflections on the relative strengths and weaknesses of customary international law?
Yeah, I think just to maybe relate our discussion of the climate change advisory opinion to discussion of actually last year's advisory opinion on the occupied Palestinian territories. I think in different ways, both advisory opinions were confronting a similar problem, which is that states were not able to agree to specific rules and resolutions of issues of international concern. So in the climate change context, not all states were agreeing to the relevant treaties, or the treaties were inadequate in various respects. And so what the court did was that they reverted back to highly general, but also fundamental principles of customary international law, due diligence, transport, boundary harm, and so on. And then through a process of legal reasoning, was able to derive relatively specific obligations and consequences for states in the climate change arena. And we saw something similar in last year's advisory opinion on Palestine, where we have this, long-standing crisis, not only in Gaza, but also in the West Bank, where diplomacy has essentially stopped. The last agreement in the arena, essentially the Oslo Accords, has been moribund for decades. And yet there was a demand by the international community for a legal resolution, or at least the legal framework of a resolution of this dispute. And so what we saw there as well is the court not only applies specific rules primarily of treaty law, international humanitarian law, human rights law, the prohibition on racial segregation and apartheid, but also relying on, again, highly general principles of customary international law, the prohibition on the acquisition of territory by force, as well as the right of self-determination, to derive specific legal consequences and obligations, in this case, the obligation of Israel to end its presence in the occupied Palestinian territories as rapidly as possible. And in so doing, the court brought these norms to bear in a context where many people might not have thought it possible. Because if you had asked people 10, 15, 20 years ago, many of them might have said, even if Israel is violating the law of occupation or human rights law in all sorts of ways, the occupation itself is not subject to legal analysis. It is simply a question of fact. But the court was able to find, again, through a process of legal reasoning, that no, because the occupation itself has become the vehicle for the acquisition of territory by force and the denial of self-determination, the very presence of Israel's military in the OPT must end. Now, when a court does this, not through a fine-grained analysis of state practice, because of course the problem we have is that states have not been able to agree on a fine-grained resolution to these issues, but doing so rather by identifying the normative principle behind these rules of custom, as well as looking at the overall normative environment provided by international law. There's always this question of whether the court is getting ahead of the law. And this is why it's important that the way custom actually works is that it's an iterative process. And so the court sets out its conclusions in its advisory opinion, and then the General Assembly takes it up, and it takes it up successively. So the initial resolution endorsing the court's decisions has a strong majority, somewhere in the 120s, but it's suppressed a bit, because the resolution doesn't just endorse the court's conclusions, it also adds certain things. A one-year deadline for Israel to leave the occupied Palestinian territories, specific obligations to impose sanctions on Israeli officials that some states were not ready to endorse. But then we saw subsequent resolutions with even more robust majorities endorsing the court's conclusions. And in this way, custom has crystallized in these norms, prohibition on the acquisition of territory by force, the right of self-determination, have crystallized to the point that whatever questions may have been raised the day the court set down its opinion, those questions have essentially been answered. The custom has crystallized. It is settled through this iterative, interactive process between different institutions and bodies, and ultimately states themselves, who are the ultimate determinants of custom. Now, of course, this has not changed anything on the ground. But what it has done is clarify the legal entitlements of the parties and thereby created a legal framework for whatever political process will hopefully actually bring an end to these crises on the ground. But it's certainly a helpful contribution in my view.
Thank you. Thank you, Adil. So Michael, do you have anything to add?
I'd like to add that I don't agree with everything
Okay.
Adil said. I don't like to talk about cases that I was counsel in, so it makes it a bit difficult. But in the advisory opinion from last year when I was counsel for Jordan, whereas this year I was counsel for the UK, but that one last year, yes, they did reach this rather remarkable conclusion that that Israel had to leave, but they said as rapidly as possible. And if you look at some of the separate opinions, I think there's a very realistic one that says, actually, you can't just leave. That would be chaos. You've got to leave in accordance with an agreement, and that's a two-state solution or it's whatever. So as rapidly as possible doesn't mean within a year. The General Assembly has no binding power. It cannot impose a fixed deadline. So I think one has to be very cautious about talking of the interchange between the law as the court may have found it and what the General Assembly then does. We had a similar problem with another case I was involved in, the Chagos Archipelago, which also used the phrase as rapidly as possible. The United Kingdom must leave as rapidly as possible. And then the General Assembly said 6 months or a year, I forget, because it didn't really matter what it said to us. Then there was the remarkable episode of a chamber of the Law of the Sea Tribunal interpreting what the court had done as deciding the dispute, whereas the court had been very careful not to decide a dispute because it knew it couldn't do that in an advisory opinion. But apparently the Law of the Sea Tribunal chamber doesn't understand the UN Charter, so be it. So what does the United Kingdom do? They eventually do negotiate a treaty with Mauritius to hand over in an orderly fashion sovereignty, but to maintain the base. And hopefully that will come into force soon when the necessary legislation has been passed. But that was done, I would say, not, in fact, the government said, not because we thought the courts had got it right, but because we thought the courts were going to continue finding against the United Kingdom one way or another, and eventually they would issue a binding decision. We hadn't had a binding decision, but we didn't want to be faced with a binding decision that we couldn't implement, that we would have to implement in an urgent way. So I think the courts have been very careful, and perhaps in the Palestine case, they've been a bit more careful than Adil suggested.
Yes, go ahead, Adil.
So I partly disagree with Michael disagreeing with me. So one rule of customary international law is about the legal consequences of breaches of peremptory norms. And one of those is that states must cooperate to bring an end to such breaches through lawful means. And then the question is, okay, well, how are states going to do that? How are they going to cooperate? Well, there's an institution that brings states together to decide how to bring violations of peremptory norms to an end, and it's the General Assembly. So while it's true, it's true, right? It's true that General Assembly resolutions as such are not binding by their intrinsic force, but if they are the means by which this obligation to end breaches of peremptory norms is to be realized, then at a minimum, a state really has to explain why they're not going along with the ways the majority of states in the General Assembly have decided to reach this issue. It's not to say they can't do it, but they need to explain why the General Assembly decides to recommend certain measures directed at Russia or some other body or some other state. Okay, you don't want to go along? Fine, explain what you are going to do. To help bring these breaches to an end if you're not going to do what the General Assembly is recommending. So This is not about the binding force of General Assembly resolutions. It is about the international community having to come together somewhere to decide how to discharge their obligations under customary international law.
Okay, thank you. And I think that does bring us back to one of the questions I set out at the beginning, which is, what are some ways in which customary international law really can serve as a bedrock, a stabilizing force, especially when treaties are very difficult to conclude in response to crises? And I think we've heard references already to some of these norms that have served a very stabilizing function and a human rights protective function, such as in wartime, norms of the principle of distinction between combatants, non-combatants, principle of proportionality. These are principles of customary international law that have recently been reaffirmed and played a major part in the ICJ's advisory opinions, including on Palestine, including on the status of the United Nations and UNRWA, and of course then principles of cooperation also as a fundamental principle of customary international law, which was reaffirmed in the recent July advisory opinion on climate change. So why don't we just focus on that for a few minutes, and then we'll open it up to questions from all of you. So why don't we turn to Una? Do you have some further reflections on customary international law as a stabilizing force?
Sure. I mean, maybe what I'll focus on here is a topic that we've already talked a little bit about, but I think deserves further discussion given how important it is, which is international humanitarian law. I've been spending my time here in Berlin working on a book on the history of international humanitarian law, and I've been going back to the 1600s and 1700s and sort of tracing the evolution of some of these critical ideas in international humanitarian law, particularly regarding protection of civilians. And what has been so striking for me in going back and tracing that process is that time and again, it's really been customary international law that has led the way. And we think of this today in the context of Additional Protocol 1, as Additional Protocol 1 is sort of reflecting customary international law. But from the beginning of the evolution of these fundamental principles, the principle of distinction and proportionality, but even the idea that there is a thing that we might call today a civilian, was a kind of invention of customary international law, and the idea that there ought to be protections for someone that we might call a civilian or a non-combatant or someone who's not directly involved in the conflict was an invention of customary international law well before we even had any written treaties governing the use of force. And even over the course of the period of time that these early protections were put in place, beginning with the 1864 Geneva Convention and the Hague Conventions in 1899 and 1907, those provisions were binding, finally created binding treaty obligations. But even then, there was very little in the way of clear protections for civilians. Those really come into play, and the sort of content is largely given meaning through customary international law. And then is later codified in treaties. We see the 1923 Hague Rules on Aerial Warfare was an attempt at a treaty, was not actually concluded. No state would actually sign on to it, but formed the foundation for what would become customary international law norms around aerial warfare, which then find their way into the Geneva Conventions and in particularly Additional Protocol 1. So at every stage, customary international has both been a stabilizing force, but it also has kind of led the way when you couldn't get states to agree to treaty obligations. Interestingly, custom was actually a step ahead of where states were in terms of their willingness to sign on to binding treaties, which is not how we tend to think about custom, but at least in this context, that is how we've seen the law develop. And so for me, this going back has really reaffirmed for me again how important customary international law is in protecting civilians in times of conflict, which at this moment when so many civilians are in the middle of these major international crises is extraordinarily important.
Thank you. Noah, do you have some reflections on this? Because I know you've advocated for a more dynamic perspective on principled non-compliance. So
for recognizing such. I'm not sure if I would advocate for it per se, but thank you. I would just add that I think crisis overall should be read as diagnostic moments that may reveal the limits of the existing law, but they might not necessarily be the right time for creation of a wholesale norm. I know it goes a little bit against what I said before, but it is part of the package, so to say. So the crisis may break the facade of stability, as Sir Michael was saying before, that maybe we have always been in a state of crisis, maybe not. But crisis can also reveal the adaptive core of customary international law, or maybe international law in general. Whether then what we get out of it is more constructive change or systemic erosion depends on how the international community overall interprets and internalizes the acts of non-compliance. If they are seen as principled non-compliance intended to change the course of development of the law or not. The flexibility that gives custom its resilience may also make it susceptible to manipulation, as I suggested earlier. And there could be claims of normative exceptionalism and so on and so forth. But another point that we should maybe keep in mind is not just the practice, but the opinio juris. So law, that part of customary international law can be really invoked as a rhetoric exercise that may not carry any legal value. I know I'm going again a little bit off the grid into more theoretical parts of what is practice, what is opinio juris, and so on, and how we interpret those. But I think it's again it's difficult but important to distinguish between the rhetoric. Is that really legal rhetoric intended towards claiming something legal or political parlance? In any case, I do think the supposed or actual crisis of international law may provide us with those, as has been referred to, constitutional moments, that there is a possibility for renewal, whether we're talking specific norms, rules of customary international law, or more overall international law as a system. And for that sort of change, it may be impossible to get there without certain level of contestation, disobedience, or non-compliance. Thank you.
Okay, thanks. Do you have final thoughts or? Yeah, so we actually, I am mindful of the time, and I did want to make sure I give each of the panelists a final opportunity to briefly respond to any other comments, since we've had a few kind of lively exchanges, which is great. That's kind of like simulating the dynamic of customary law after all, right? Sir Michael, it seems that you might have something to add.
Could switch this on, yes. Well, first of all, I don't believe in constitutional moments in international law. There's no constitution. The UN Charter is not a constitution, it's a treaty. And I think it doesn't make sense to talk of constitutional moments. There are, however, sort of urgent moments, and they usually lead to bad law. A good example in my mind is the short-termism of governments who say, oh, it's perfectly good to prosecute a serving head of state for a crime. They're going to regret that. In fact, they're regretting it already, I suspect. Things like that. I think some of the really useful rules of law, which maintain stability in the world, are under threat to some degree. Just one last point I would make. A very interesting sentence in the advisory opinion from 2 days ago, to my mind, is about customary human rights law, because I was brought up to believe there was no such thing as customary human rights law. There were treaties, and they were all a bit different, and there really wasn't any customary law. Hugh Thirlway very strongly took the view there was no such thing as customary international human rights law. The court 2 days ago said both the human rights treaties to which Israel is a party and customary international law encompass a wide range of human rights that are relevant to the population of the occupied Palestinian territory. So that's a very clear statement by the court, which I actually believe is right, despite the fact that I was taught otherwise. And I think that's a quote. This is something where the court, although it can't change the law, it can't develop the law, it can bring clarity. And that's a very important sentence. I don't know whether it's been said before as clearly as that. So I'll end with that optimistic note.
Okay, that's a great way to end, unless, oh no, you have any further reactions to? No, good, okay. So now we can hear actions, and we're excited about that. So let me just suggest that perhaps we take about 3 questions at a time, and then the panelists can respond. I would ask that you identify yourself and then try to frame your question as a question, as opposed to a comment, unless it's very, very brief. And so why don't we open it up to a conversation with you? I'm not sure if we have a dedicated mic for that purpose. Okay, we have one here, Tim, so I'm here. So one more, we have a third. Okay, why don't we form a little line here? Do you mind if I borrow this one? Lack of an official mic. Okay, so we'll just pass it around. Okay, I'll play. Thank you very much. Sure.
So I wonder if it's possible or advisable, as Sir Michael did, and as I think others of you do on the panel, to speak of customary international law as being created by states rather than as being discovered or recognized perhaps by states. So when we speak of, as we often do, of international custom as evidence of a general practice accepted as law, I wonder if accepted as law reflects some other and more fundamental source of law than the naked will practice of states.
And we'll take 2 more, and then panel can.
Thank you. Hi, my name is Kenza. I'm a student of international law. I study at Strasbourg in Paris. I had a question for Nora, but also for any of the other experts who want to interject on the concept of principled non-compliance. I think it's really interesting. You mentioned that you wouldn't necessarily advocate for it, but it's an interesting theoretical lens to apply. My question is, why would you or wouldn't you? And kind of potential floodgates could be opened for things like just cogence and prohibitions on torture, things like that, if we start to look at principled non-compliance as a new kind of metric for international law.
Thank you. Do we have a third? Okay.
Really interesting panel. My name is Tom McDonald. I teach at Pace Law School. My question is this: given the rise of the right in the United States and in many Western countries, we talk about President Trump, his threats regarding Greenland, his threats to Panama, other small Latin American countries, his bombing of boats containing smugglers. Okay? And also, if you take a look at some of the European countries that have turned to be ultranationalists, okay, how much of a threat is this phenomenon not only to customary international law, but also to international law generally?
So do our panelists have reflections on each of those questions? Why don't we go to Tim's first, and then we can turn to the one for Nora.
I'm happy to give it a try.
Okay, we'll start with Una then.
Although I'm sure that Michael has more to say about this than I do. Just on the first and third question. So on the question of is customary international law created by states? I think I would agree, and I'm curious if the other panelists disagree, that customary international law is not created by courts. That statement I agree with, is recognized by courts, but it is created by states. It's created by states through their opinio juris, recognition of opinio juris, and through state practice. And so I don't think we're wrong to say that there's a state there's a role for states in the creation of customary international law. It is an iterative process in that, you know, states obviously are interpreting and understanding their obligations and articulating what they understand their obligations to be. They're accepting the customary international laws that exist when they come into existence. But then they are co-creators of customary international law over the course of time through their role in recognizing opinio juris and state practice, or at least that's how I would think about it. And if others think differently, I'd be curious to hear that. On the last question on the rise of the right, you know, I think the place where I see the greatest threat is to what I believe to be the kind of core underlying norm of international law, which is the prohibition on use of force. I see at this moment that core norm, which obviously is embodied in the UN Charter, but also is a customary international law norm that is, I think, the kind of fundamental underlying principle of the international legal order is, you know, under threat now more than it has been perhaps in the last 80 years. We see 3 of the members of the Security Council willing to potentially flaunt this principle. We see China, its actions in the South China Sea. We see Russia, obviously the invasion of Ukraine and otherwise infringing on its neighbors. And the Trump administration's willingness to suggest that the US might make Canada the 51st state, might take back the Panama Canal, and the actions that it took in bombing nuclear facilities in Iran. I think all of this is really troubling and dangerous, and is not just a threat to that principle as a kind of standalone principle, the principle on use of force, because that principle is the kind of underlying principle of the international legal order. I think it puts the whole global legal order at risk in the process. So I do think it's not necessarily a left-right divide, although I think there are ways in which it seems to be aligning that way. And I do think we are facing really a critical threat to international law more generally.
Thank you. Kind of goes back to Sir Michael's original point. So I'll invite Sir Michael to comment, and then Adil, and then we'll come to Nora.
Well, very good questions. But firstly, I'd like to disagree with the last panelist.
Today.
I think that, of course, the rules on the use of force are often disobeyed or questionable actions are taken. But I don't see that any worse this year than last year or 10 years ago. And, you know, words are easy to say, I'm going to take over so-and-so, but that's not a breach of the rule on the use of force unless you go ahead and do it. So I really don't see that as a particular threat, though it's a very serious matter if it is a threat. I wanted to respond to the last question. I think, yes, we should look both at customary international law and at treaties. And I think it's wrong, really, and this panel is wrong to be looking just at customary international law. You have to look at the whole range of international law, custom and treaties, and anything else that may be knocking around there. General principles of law recognized by so-called civilized nations or whatever. But you've got to look at it overall. So I wouldn't, but I do think that as things begin to fray, as the challenges come about, customary international law is more robust because it can't be changed too easily. Just a word on breaches of customary international law. Of course, some of them are constructive. If they're going in the direction with the thrust of the law or with the thrust of worldwide opinion, that's one thing. And you think of Canada extending its fisheries well ahead of everyone else. That was probably a breach of the law at the time, but it led to a change in the law, which has become generally accepted. So there are positive breaches of the law, in my view. I'll stop there because there's so many other questions one could answer, but I won't be tempted.
Thank you.
So I'll take a swing at Tim's question. So I think what Tim, what you're asking is, what is the role of ethical or moral considerations in customary international law? Is that, so I think that, look, the existence and content of a rule of customary international law is a matter of social fact. And that's important to remember because that means that the law can be morally defective in various ways. And it's important to have a separation between what the law is and our moral convictions so we know when to critique the law and when to advocate for its being changed. At the same time, I think that in another way, moral argument is critically important in the formation and crystallization of customary international law because states necessarily will seek to justify their legal positions in moral terms because these are rules that are supposed to apply to all states irrespective of their self-interest in which they're going to be expected to obey even at some cost to themselves. And so necessarily you're going to have to offer a normal justification for these rules to explain why states should accept them as law, as having legally binding force. And those considerations will inevitably at least overlap with or include considerations of justice.
All right.
Thank you. It seems all of us want to engage with Tim's question a little bit, so I'm going to be very brief on that. As I've written elsewhere, I think customary international law at the first stage forms like a path in a forest. So you don't know where it came from. It's appearing from somewhere. The animals have been walking on it, some other people, who knows? But it's there, and then you notice that you discover it, and from that point onwards the manipulation, if you like to use a negative term, is open, that you could maybe try and create side paths or make sure nobody takes that path anymore. So I think that's kind of how I would see the creation, if you like, of customary international law. Going to the other question, thank you, Kenza. Why would I not, or why would I advocate for something like principled non-compliance in the lawmaking? I think lawyers have not engaged with this very much. It's the ideas come more from the IR scholarship, the constructivists. But I mean, why I wouldn't, first of all, would be that I think there is a confusion that this could create if you really would advocate recognizing law, customary international law this way. And we have persistent objectors who can say we do not agree with this, but only from the initial onset. We have also a very negative connotation with the idea of non-compliance or violation or breach. But at the same time, when we think of this in a domestic setting, there may be situations where we have bad law. And in a democratic system, I'm not saying that the international law necessarily is that, but in domestic terms, this change may arise indeed from non-compliance. So that's also part of my thinking there, that how this idea may be reflected in international law. And finally, I think as I said, it could be a catalyst rather than a fully fledged idea. If it would be more fully fledged, such creation of law through non-compliance would have to come within the specified limits, such as not going against your slogans and respecting the principles of the rule of law, whichever you may determine them to be. And that already makes this idea a bit of an artificial construct. Thank you.
Okay, thank you. Other questions? So we'll again take 3, and we'll start here, and then we'll come back here. So.
Thank you. Hi, my name is Ryan Stoger. I'm a practitioner. I had the honor of being Sir Michael's intern at the ILC a long time ago. So I did want to go back to the issue of General Assembly resolutions. And I wanted to ask Michael, Professor Hack's opinion, others, if they want to chime in, about the line between the political and the legal in these resolutions. So when the General Assembly adopts these resolutions, even when it welcomes or endorses the opinion of the court, is it actually endorsing all of its legal reasoning? To take the example of last year's General Assembly, advisory opinion on the occupied territories, when the General Assembly says what it says, is it actually doing it as a matter of law. So does it accept the principle or does it accept the bottom line? Would states then, for example, if there's a rule on prolonged occupation, that's a tool for annexation, would these states accept such a rule in the context of Western Sahara, the rapid situation in Russia, Ukraine, Northern Cyprus? I wonder if states actually accept that application on a more global level, or is this just a political implementation of the court's opinion? Thank you.
Okay, I saw a couple hands here. This is exciting. We have more hands than we're probably at time. And I do plan to go over at least 5 minutes because we got a bit of a late start there.
So, okay, Annabel Casamoron from the Geneva Graduate Institute. So my question is regarding one of the panelists mentioned the role of not only the customary international law, but also other actors. So I'm talking about international organizations. What is the role of international organizations and region complexity? So of course, each organization has a mandate. Some mandates are overlapping. They are sometimes contradictory. How to do and how we deal with that? Thank you.
One more. I'll try to treat both sides evenly here. I did see a hand here. Okay.
Thanks. Elise Kepler, Global Justice Center. I appreciated the comment about international law under threat in this moment. And I actually wanted to put to the panelists, when I think about some of the crises that are going on, more than ever in my career as an international lawyer, I'm getting the question, not is it under threat, but does it have any relevance? And, this is somewhat of a practitioner question, perhaps more than an academic one, but I would love to hear from each of you as esteemed panelists on these issues. What would you say in one sentence about the relevance of international law as we see it increasingly flouted? Or maybe not, maybe there have always been crises and always flouting. Thanks.
Thanks. And actually, because of the time and interest of facilitating our discussion, maybe we can take at least 1 or 2 try to give the back of the room a little bit of opportunity here. So how about back here?
Thank you. I'm Zayman F. from Human Rights Watch, and your comment about customary human rights law really struck me because I think about the right to education and particularly the right to primary education and non-discrimination and its potential for being customary international law. But the question on crisis as catalyst made me instantly think of the pandemic and the disruption of education for 1.6 billion people, and how that has catalyzed movement towards a new education treaty that would provide free education, including pre-primary education through secondary. And potentially, in decades, think about expanding the core of what we consider customary international law. But my question was, in the context of such a difficult and bleak moment, are there areas of hope, areas where you still see potential for expansion, or areas where you'd like to see expansion?
Okay, I think we'll go from this side in the back, and then oh my goodness, this is exciting. I wish we could continue our, well, we'll see how far we can go. Yes? Did you have yeah, I'm mindful of the time. Until 12:30? We actually go till 12:45. Yeah, but I'm going to extend it using the chair's prerogative and under a customary law that's developed at this international time, because this is wonderful. I love having this engagement. So we're going to try to empower as many participants as we can here.
Sure. So my name is Douglas Pivnichny. I'm with the United Nations, but obviously here in a personal capacity. I want to follow on a bit from Tim and Aaron's questions. We haven't heard anything about states discussing customary international law. And I'm reminded of the ongoing conversation in the Sixth Committee about whether to have a conversation about whether certain aspects of the articles on state responsibility reflect custom. And so I'm interested in your views, should states have more conversations amongst themselves about the content of customary international law, or is that risky, do you think?
Thank you. Okay, I know there are other questions. I'm so sorry. It's too bad that our time is limited, but feel free, panelists, to address any of those 5 questions that you would like. And again, we'll try to be as brief as we can. Go ahead, Sir Michael.
Well, very briefly, in response to Aaron Stoger's question, I think we have to be very cautious about General Assembly resolutions. Even when they appear to be saying something about the law, states don't think before they vote quite often. They don't go into the legal issues. It's different from drafting a treaty where usually a lot of care is taken. But Rosalind Higgins, in her 1960s book about the role of the political organs, made it clear that you can't take that seriously everything that the General Assembly says. Sometimes it's done very carefully, like the Friendly Relations Declaration from 1970. Other times it isn't. And the International Law Commission was very clear in its conclusions on customary international law. Contrary to my view, actually, they put as a first paragraph, resolutions of the General Assembly are not generally relevant for opinio juris and the like. So it's quite interesting. And just to pick up perhaps on the last question, whether states should discuss customary international law. Well, I think they do, but tend to do it in smaller regional groups. It's difficult if you get into a very large group, but state responsibility, those articles, virtually all of them have been said by the court anyway to be customary international law. And in the climate change opinion, they actually said most of these provisions are customary international law, which is quite good, I think. And it's one reason why we don't need a treaty on the subject, which I think would be very bad to turn it into a convention because it would all fall apart. But I just wanted to say that because I feel strongly about that. Thank you.
Adil?
So with General Assembly resolutions, I think it depends on the resolution, right? So the definition of aggression, the Declaration on Friendly Relations, right? Throughout its history, the General Assembly has been an incredibly important source for the crystallization of customary international law. So I think you have to look at each resolution on its own terms. You have to look at explanations of vote. Now, what you were suggesting about kind of consistency, right? Will states take the same legal position in different conflict areas? My own view is that it is good to catch states when they're acting in a principled manner, and then later, when they try to act in an unprincipled manner, use their words or positions against them. So I would actually leverage these opportunities when states are thinking in a more high-minded way, and then beat them over the head with it when they're doing otherwise.
All right.
Thank you. Yeah, I would just address briefly the question on international organizations and customary international. If I understood correctly, that was sort of overall question. So my take here is that if you look at the classic formation of custom, there is an element of reciprocity of sorts, but there is element of consent. And intergovernmental organizations do not themselves directly contribute to the practice of how custom forms, hence they would not be bound by that either. I know Sir Michael probably has much more to say on this and what I have seen in the ILC reports, but I will leave it at that. Relevance of international law, in one sentence, this could be two. I think it's not obsolete. States do, even in our current crisis, if you would like, refer to international law, even if the actions may not always support that. And the prime example here, I think, is that states are withdrawing from treaty regimes rather than simply ignoring them. Thank you.
Thanks.
Yeah, just a couple of the questions, which are all wonderful. On the question of should states be more involved in discussing custom, I think the answer is absolutely yes. And in particular, what I will say is that we often, because custom is opinio juris and state practice, there's certain voices that sometimes are more easily heard because they are more vocal about their views about what the law is. And that does have sometimes a negative impact. It means that we count fewer voices than we should. And so, I would suggest that actually more states ought to participate in that process of articulating what they understand the law to be and being clear about what their state practice is so that they can play a role in shaping our understanding of what customary international law is. I mean, I think there is a kind of history of customary international law of just looking at quote unquote civilized nations or practice of civilized nations. We're clearly past that, but there's still certain nations' practice that's more visible and nations' views about the law that's more visible. And so I would encourage more states to play a greater role in articulating their views. On the question of international law under threat, I think this is really the key question in a way. It's one I've spent a lot of time thinking about. And when I get this question about, is international law under threat? Is international law up to the moment? Is international law, does it actually make any difference? One thing I think is important to note and to remember is that international law is most visible when it's violated, but it's in a way, it's all around us and it's frequently extraordinarily effective. I mean, the fact that we have had is the most peaceful era in living memory, for the last 80 years since the UN Charter has been in place is largely because interstate war has declined significantly over the course of that period, largely because international law does work. We notice it most when it breaks down, when it fails. And I think in a way, a job of international lawyers is to tell the story of international law, not only at times of failure, but to tell the story of international law at times of success. I mean, there's so much that really is working about international law. There's a lot of success to be celebrated about international law. And even at moments where we feel like things are under threat, and where there's a lot of challenge, I think we have to keep in mind that there's also, extraordinary success story here, and one to be celebrated.
Thank you. Well, maybe this is a good time to conclude on that hopeful note. I'm so sorry we weren't able to get to all of your questions. I think that just demonstrates what an important subject this is. Thank you all for coming now. Here's the moment you've all been waiting for. Okay, not only did you get wonderful enlightenment from our panelists, but you also can get CLE credit. Yes, so here's the magic word for those who would like CLE credit. It's Santiago. Santiago, okay? So again, please join me in thanking our panelists. Thank you so much. And now enjoy your lunches.